Welcome to Advocating for Dads with Jana Jones.
Hey everyone, welcome into an all-new episode of Advocating for Dads with Jana Jones. I am your host, Mike Leon. Jana here is a North Carolina family law attorney. She's based out in Charlotte. She's been helping fathers out there protect their rights and stay involved in their children's lives. And in today's episode, we're breaking down joint legal custody. Jana's going to explain how decision-making really works when parents share custody in the state of North Carolina. Jana, it's always good to see you. To start here, could you explain the difference between joint physical custody and joint legal custody?
Hey, Mike, great to see you again as well. So, the difference between joint physical custody and joint legal custody comes down to the type of custody. When you're talking about legal custody, you're talking specifically about decision making. So these are things like, where does the child go to school? What type of medical procedure or medication does the child take? What extracurriculars might the child be involved in? Or what religion does that child practice? Those are kind of the four big buckets as it relates to legal custody. And generally speaking, North Carolina grants joint legal custody to both parents, regardless of the physical custody arrangement. Now, when it's related to physical custody, joint physical custody means that each parent has at least 123 overnights or more per year with the child or children. If that's the scenario, then the parties have joint physical custody.
And so let me ask about the joint legal custody. So now they share this legal custody. What kinds of decisions are they expected to make together?
So they're expected to make all decisions together. Now, because parties who have custody orders generally are not going to get along all that great, or they may have some issues that they have to work through, the court understands that you can't come there every single time you disagree on a decision related to the child. So for instance, if you are trying to decide what school to put the child in, maybe one parent wants to put them in the local public school and another parent wants to put them in private school, and you have joint legal custody, what that means is each parent is supposed to speak to the other about what they think is best for the child, and then hopefully they can confer and agree and make a decision. But sometimes you cannot come to a decision, and so there's generally some type of tiebreaker language in your order. There are a few different options for that. One can be arbitration, where you are more or less, it feels like you're having a little mini trial. You're in front of an arbiter, not a judge, and that arbiter is an attorney, and you can put on evidence. So you could say, hey, I want the child to go to this public school because they've got this great program. Other parent can say, hey, I want the child to go to the private school because of, the educational credentials that I'm looking at. And that arbiter will hear the arguments, take any evidence in, and then make a decision that is binding for the parties. Another option is mediation. In that role, the mediator, who's usually an attorney as well, is just there to try to help the parties facilitate an agreement, but they don't make any decision for the parties. And so they try to help the parties come together to agree. And then another option is final decision-making authority being given to one parent or the other. And what that means is that the parties are supposed to confer together to make decisions. And then if there is not an agreement that is reached, one parent kind of has the trump card and gets to decide what happens.
Jana, you mentioned school choice, but does that same scenario of options apply as well on medical care with respect to how the court expects them to handle it?
Absolutely. So any major decisions that affect the welfare of the child are considered legal decisions, and the court generally will award joint legal custody and expect the parents to confer and agree on those decisions. Medical is definitely one of those.
Yeah. Can a judge give both parents equal time with the child, but still give one parent, let's say, final say on some of these major decisions?
Absolutely. That happens pretty regularly because it is difficult to require the parties to go to mediation or arbitration sometimes, because that is going to be an additional cost. In some families, that's just not tenable for them. So in that situation, I have seen the courts grant final decision-making authority to one parent or the other. That's generally going to go to the parent who's historically made those decisions, or the one that that the court believes it is going to make the best decisions for the child based on the testimony that they've heard.
Speaking of the court, the North Carolina judges, are they especially careful about dividing parents around certain issues? We've touched on school choice and like medical decisions, but like religious choices, are there other certain issues that we're maybe not considering that the judges out in North Carolina are very, very careful about dividing the parents?
I would say the big three are going to be medical, education, and religion. Extracurriculars will fall into that as well. You know, if one parent is particularly involved or motivated by a particular sport for their child, that might come into play as well. But the three big are going to be religion, education, and healthcare decisions.
And what do you recommend for the dads out there listening who feel maybe the other parent has been making all the big decisions alone, even though the order, like you said, is joint legal custody? What do you recommend that they do?
So I recommend that they get involved in that conversation. You know, if mom's saying, "Hey, I want to take the child out of this school and put him in this school," well, wait a minute, why? Let's talk this through. And if they don't feel like they're being heard, if there is final decision making authority and she has it, then unfortunately, her decision is going to be what the court would respect. If there's anything in the order that speaks to the joint legal custody and it talks about what's supposed to happen as it relates to the conversation that the parents are having, and there is a violation of that, then, like I said in a previous episode, you may want to consider contempt so that you can get the court to tell this parent that they do have to follow the order and include you on decisions.
And what about if a parent just keeps ignoring that agreement? Like, what can the other parent do? Can they ask the court to change the order?
There is a difference between modification and contempt. So a contempt is in the situation where there is an order in place and there is a specific provision within that order that one of the parents has violated. And you're asking the court to enforce and punish the other parent for violation of the order. A modification is asking the court to change the order. So, generally speaking, if a parent is violating a provision of the agreement on a regular basis and you want the order to be changed because of that, you're going to need to file for a modification. You have a basis for a contempt if they are violating a specific provision, but in order to get the court to consider changing your order, you must file a motion to modify.
Jana, I've asked you in previous episodes about how detailed you would advise people make these custody orders. So, in that same vein, how detailed should the custody order be to so that way we prevent the confusion about who's making the decisions?
So you want to make a custody order as detailed as possible because you don't want there to be any ambiguity or confusion. One, because you want to make sure that you can actually use your order to live in the real world. And the other reason is because you want a specific provision if you're trying to hold the other party in contempt that you can point to say, hey, they violated this provision. If your order is too vague or general and the court can't determine exactly what was meant or what was required by that provision, then the other party cannot be held in contempt.
Jana, for dads out there, they're trying to co parent very smoothly under the joint legal custody framework. What's a habit or maybe something that you've seen work well that they should use to avoid future conflicts?
So I would say it's important to keep as much as you can in writing. When you're having a conversation with someone, things could get lost in translation. People are constantly on their phone and distracted and multitasking. And so something might be missed, and it might be an honest mistake where you thought you heard one thing and somebody said something completely different. So if you reduce it to a writing, whether it's an email or a text message, that's generally going to be the best way to deal with those small issues. Overall, though, if you have significant issues related to custody, your best piece of advice is to get a custody order.
Jana, thank you as always for the time and insights on this. We truly appreciate it.
Thanks so much.
And that's it for today's episode of Advocating for Dads with Jana Jones. Look, if you share custody, you want to understand your legal decision rights in the state of North Carolina, do me a favor right now. Visit lawofficeofjkj.com. Schedule a consultation with Jana and the team. Don't forget to like, subscribe, leave a review, and comment on this episode or share it with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one.